2-08. This matter, we have Mr. Zandy here in the courtroom with his client. We have Ms. Winkles online. I don't know if your client is.
Yes, my client's here online as well, Your Honor.
All right. So in regard to this matter, first, I apologize for the late notice on this, but upon reading all of the documents, there are just too many names that I know, and I just don't feel it's appropriate for me to continue, and so I will be recusing on this case. That would mean, because I believe there's a nod on Judge Basher, and so that means it would go to Judge Evans' docket. So that would be Wednesday. At what time?
9 o'clock.
At 9 a.m. So we'll move it to Wednesday at 9 a.m.
Very well.
Okay. This Wednesday, Your Honor?
Correct. This
Okay.
is
Thank you, Your
a
Honor.
request by Ms. Winkles to withdraw. We have Ms. Gilmore. Anyone else other than Ms. Winkles on this matter? Hearing none. So the request has been made. Ms. Gilmore, I don't know if you had anything you wanted to say. You're muted, or I don't have sound from you.
To the best of my knowledge, Your Honor, she was in agreement. She has no objection.
Okay, thumbs up from Ms. Gilmore. So with that, hearing no objection, or seeing no objection, I should say, I will go ahead and grant your withdrawal.
Thank you, Your Honor. And I'm not sure another attorney needs to be appointed at this time. It seems that that everybody is in agreement. My client seems to be in a good place.
Okay.
I'm assuming that Ms. Gronitz has no objection. She's here today with a continuance of 2 weeks. She submitted discovery. It was a review. It's Gronitz v. Boss. I just want the chance to be able to go through that and then contact her. We did receive a bunch of stuff.
So there was also a presentation of order. I don't know. I don't have an order that I see.
You should have an order, but it came a while ago, so we'll go ahead and send another one. It was just the order from the last hearing.
Okay. All right. If you could cover on there and just the explanation of present and that kind of thing would be good.
Absolutely, I will do.
All right. And with that, do we have Ms. Gronitz?
Yes, Your Honor, I'm here.
Anything you wanted to say?
Actually, my financial auditors are requesting 60 days to perform their audit. Ms. Winkles is certainly welcome to the 2 weeks, but I honestly believe that if this doesn't get resolved in the 2 weeks, the auditors are going to need 60 days. We have a $30,000 deficit in accounting. So I would love to work with counsel and find that gap and get this figured out, because I can't give her the income statement she's waiting for until this gets resolved.
And I don't know what I have, so I just asked to set it over and then we can discuss it then.
Okay. So it needs to be set over to May 14.
That's fine.
So I'll go ahead and set it to May 14, and then maybe figure out from there what's done. I'm not sure what the topic has to do with it.
That works for me.
So we'll set it over to the 14th and go from there.
Thank you, Your Honor.
9 a.m.
9 a.m.
Thank you.
That'd be Copland and Yonich. Anyone here on that matter?
Yes, Your Honor, Meredith Long is here on that matter.
Okay, wait just a second. So, Ms. Long, what I didn't see is service. Was there service?
There was. I have an email in my own files from Mr. Yanich's attorney saying that he was authorized to accept service. However, I couldn't get him to actually sign an acceptance of service form. I have corresponded with him about this case since then. I'd like, and I understand that Your Honor probably can't proceed without something on file today. I would like to make an oral motion to get the court's permission to maybe give me permission to just serve via email to his attorney. I don't have an address for Mr. Yanich, and I can't get his attorney to provide me one. So I'm just a little unsure how to proceed here, but it seems like we should be able to proceed since he has an attorney.
So in regard to that, it does need to be a written motion. I can't do an oral, especially when it comes to service. So I would just submit it ex parte to ask for service by an alternative and go from there and see what happens. You want to set this over to the 14th and
Yes, please.
okay. All right. So let's go ahead and set it over to the 14th and allow you an opportunity to get that motion filed. And then we'll see what happens on the 14th.
Okay, thank you.
All right, thank you. Your horn be Worrell.
I agree, Judge.
Do I have Mr. Zandy here in the courtroom? Do I have anyone else present on this matter?
Present, Your Honor.
And this,
Lakin, Airhorn.
thank you. Okay,
Casey Looney on behalf of the state, Your Honor, for child support.
thank you. So I have a parenting plan here. I did not see any objections. Mr. Zandy?
Yeah, we're here for two functions today, Judge. Number one is presentation of that order modifying the existing temporary parenting plan. We've submitted that. We did get information from Ms. Airhorn, not specifically related to any objections, but just some other matters involved in this case. I don't know if she has any objections to the form of this or not. Also need some direction on GAL order. This is one where Ms. Turnbull has graciously accepted reappointment. In review of the file, there's already an existing GAL order that nobody really, I believe, followed through with. We did change the percentages that the parties owed. My suggestion, or I guess my question would be, do we need a new order specifically, or should we go under the existing order, which really identifies many of the same problems? I'm fine either way, just need some clarification to that.
Okay. So let's first talk about the parenting plan. Ms. Airhorn, were there any objections as to whether this represents a ruling of the court?
So the temporary order I got this morning before court was the drop off would be at 5:30 Wednesday after work and then Sunday at 6. When we exchanged Declan this last week, it was at 5 o'clock. I coach his soccer team and I have to come to Castle Rock to drop him off, then drive all the way back to Longview to coach practice on Wednesdays and Fridays. So I was just going to ask if we could keep the drop off and pick up time at 5 p.m. in Castle Rock at the police station.
Mr. Sandy?
I don't think my client have any objection to that. He is present.
I am here. I'm okay with that, Your Honor. This is Daniel Worrell.
Yeah, that's fine.
So I believe the only place that I need to change is on paragraph 8B.
Correct.
Okay. So I'll change to 5:30 to 5 p.m. Okay. Anything else, Ms. Airhorn?
And then is that Sunday going to stay at 6 or is everything going to be at 5?
I have Sunday at 6.
Okay. And then another thing I was going to ask, I wasn't sure for tomorrow. So the off week, did Danny still want to do Wednesday after work at 5 until Thursday at 6 p.m.?
Are you talking about just a one-time change or what are you talking about?
So it says on here, the first week, it would be every other Wednesday through Sunday. And then on my week that I have Declan he would get my Wednesday to Thursday on his off week.
Mr. Sandy?
Yeah, specifically, Judge, I don't recall that being, I'm looking at that now, and if that was inadvertently placed, so I don't recall that being a specific order. I thought for a month and a half it was every other weekend, Wednesday through Sunday. I don't know if the clerk's minutes reflect something different than that. I know we had proposed that in the off weeks there was another Wednesday overnight to Thursday. I don't know if the court formally adopted that proposal or not. So I don't know that needs to even remain in the parenting plan outside of just the every other weekend, Wednesday to Sunday.
Let me look at the clerk's notes and see if I can. So Ms. Airhorn, what I would ask is that in the future, when we have things like this, that you contact Mr. Sandy ahead of time to talk about these things, so we're not taking time from all the other cases.
Okay.
So the court's ruling visitation for the months of April, May will be overnight, Wednesday to Sunday, every other week, off week, Wednesday overnight to continue to end of May. So there is an overnight on Wednesday.
There's, okay, just one clarification. So it looks like the order is correct.
Okay. So it has Wednesday until Thursday. Is that, Ms. Airhorn, what you're talking about?
Yeah, I just wanted to make sure. I just wanted to ask if Danny wanted to do that for that one overnight, or if he just wants to keep it every Wednesday through Sunday. I'm fine either way.
Okay, well, I'm going to go with what I ordered at this time. So if you agree to something else, then Mr. Sandy can present an agreed order. So at this point, this appears to represent my ruling. So are you, Ms. Airhorn, are you okay to put approved via Zoom?
Yes.
All right, I have signed that order, and that puts that parenting plan into place. Mr. Zandy, in regard to the guardian ad litem, I think what would probably be best is maybe to just do a simple order that says that the guardian ad litem's order of whatever date it was will continue.
Okay.
And at the same rate, or
We changed the rate. That was one of the things I think that probably
Okay.
justifies that second order. You put 50/50 with the reimbursement reserve language.
okay.
So I'll amend that existing order with the few changes that we have here.
All right, Ms. Airhorn, does that make sense?
Yes, Your Honor.
Okay. All right, so let's just get that and then get that to me for signature.
Very well. And then finally, Judge, you did reserve on the issue of child support moving forward. Given the change in the parenting plan, as well as the change in circumstance to my client who had a new baby that was born as of November of 2023. We did file on April 15th an update related to his financial circumstances, gave you some sealed financial source documents by way of a pay stub, I believe, kind of reflecting where we're at with that. My client details for you that he works at Weyerhaeuser at the rate of $35.61 per hour. We've used that to calculate his income. If you look at his pay stub, there is overtime included in that. My client has worked essentially every bit of overtime he can, expecting the legal fees, the GAL fees, the court costs and such to go up, in addition to having another mouthful fee in his family. So for purposes of support, I simply took his hourly rate, I multiplied that by 40 hours per week, 4.3 weeks per month, and I get a net income of $4,581. Did not receive any information from Ms. Airhorn, and we essentially imputed her an income of $3,500. Again, that's a net, as my client has a lot of unknowns and uncertainties about what her current work status is. We do believe that she's working in a nursing home or a care facility. She can address that certainly. But again, I think for purposes of today, we estimated the best of our ability, we come up with that $3,500 per month. My client is asking you to consider both deviations. That would be the whole family deviations for the 2 additional kids, in addition to Declan, that he is now supporting in his house. Also asking for the overnight residential credit, which would coincide with the week on, week off parenting plan that will be in effect here in a little over a month's time. If you give just credit for one of the overnights, or excuse me, one of the deviations, it could result in a transfer of $445 per month. That would be the whole family. If you apply the overnight residential credit, that would be lower his support obligation to $111. And if you gave him credit for both, that would essentially zero out the child support issues. We have provided information to the state of Washington. I did not get any specific response from Ms. Looney, although I'm certain she's prepared to address that here momentarily. But we believe that is the current circumstances, at least for my client's income. Again, acknowledging the unknowns for that of Ms. Airhorn.
Ms. Airhorn, why don't I hear from Ms. Looney at this point, okay? Or not?
Okay.
Yeah, go ahead, Ms. Looney.
Thank you, Your Honor. In this matter, the state's interest is just regarding the medical support for the child. So we would just be requesting to enter incomes as accurately as possible for the percentages for uninsured medical and any childcare costs that might arise. I did review the proposed worksheets for Mr. Zandy, and those income amounts did appear accurate based on the information I had at the time. We did receive some information from Ms. Airhorn late yesterday. I did review it this morning about her income, and in that she stated she makes $19 per hour. I don't have any additional information other than that. So the state would be in agreement with entering an order today with Mr. Zandy's proposed orders and defer to the court on whether you'd want to set that over to have time to review any additional information Ms. Airhorn may have filed late. We would just be requesting for medical language that we include that the state medical is provided by mom.
Ms. Airhorn?
That is correct. And I did file late yesterday because my work schedule's been crazy, but I did drop off a copy to Mr. Zandy's office this morning beforehand as well.
So you're making $19 per hour?
Yeah, and I work off of 1099, and I'm getting like 25 hours a week. So I have to take 20% out of my paychecks. I get paid over through Cash App. So right now my monthly income sets up about $2,100 a month.
Mr. Zandy?
Yeah, I did not have a chance to review that prior to leaving today about 8:30, so I'm not sure what time that came in. If it's there, I'm happy to take a look at that and calculate it accordingly, but we would ask at minimum that she be imputed at full time, which would be 36 to 40 hours. Compare apples to apples, the same way we're doing with my clients.
Okay. So here's what I'm going to do. In regard to the father's income, I'll set it at the 4,581 net per month. In regard to the mother, I will, at this point, if the documents support it, the $19 per hour, but I will do 36 hours per week imputed. In regard to the getting credit, I will adopt the whole family credit. But the court feels that anything else would make it, there wouldn't be sufficient income or child support into the mother's home to support and take care of the child. So I'm just going to go with the one whole family.
Very well. And do you want to set this to the 14th for formal presentation, that child support order?
That would be fine.
At the same time.
Yeah, that would be fine.
And Ms. Airhorn, I'll email that to you if that's okay, and send a hard copy.
Yes, thank you.
All right.
Thank you, Judge.
Thank you. That should take care of that matter. The bondurant matter.
That matter's ready.
All right. This matter is on for a final GAL report. We have Ms. Bliss. We have Ms. Is it Call? Okay, Ms. Call. And do we have Mr. Bondurant?
Yes, Your Honor.
Okay. So the only thing for today was to make sure that the final report was done. It was filed on April 18. So with that, is there anything further from anyone?
Nothing for me, Judge. I agree that it was filed on the 18th. I did receive that document, and I have not had the opportunity to discuss that with my client. So I would ask that the court just strike the matter today.
Mr. Bondurant?
That's fine.
Okay. All right. So the report's been filed. Nothing further needs to occur. And we'll just go from there.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
I have Mr. Zandy here in the courtroom. Do I have Natasha Colley? Natasha Colley. Do I have Amy Turnbull?
Yes, Your Honor, I'm here.
Okay.
Judge, this is on for various forms of relief. I think the pleadings speak largely for themselves. Would inform the court that we were finally able to find and locate Ms. Colley. She's apparently employed at a place in Portland, potentially conceivably residing there as well. Personal service was finally executed on her on April 6th. Knowing that service was going to be an issue, and my office had drafted a motion to serve via mail. She's extremely transient in her living environment over the past year and a half or so. Didn't have to go that far because we were fortunately and got somewhat lucky able to locate her, have her served. It wasn't until April 6th, so we're a couple of days short on that. We did amend our docket notices. She was provided those, setting everything over to May 14th. For purposes of today, and this is the probably most disheartening aspect of this case. This is a young man who's in junior high school, or I guess more appropriately middle school, who's essentially had a wasted year of 2023 and 2024. He's significantly behind. My client has pled with the Longview School District since assuming custody of William back in February to let him be enrolled in the school district. They will not do that. They will not soften their stance and position related to enrollment without a court order. We attempted to get the immediate restraining order permitting that. That wasn't good enough or suffice. What we're asking for today, and again, here we are in late April already, but at least get the school district on board so this child can resume normal activities and not waste any more time. So we are asking for a bench order today that just simply states the child can be enrolled in the schools in the Longview school system, commencing immediately, just so we can hopefully get this child back on track, and we'll address the other issues on May 14th. I don't assume that Ms. Call will appear. She's been extremely absent. I can tell you that she's had no communication with the child since, I believe, February. She's had no interaction with my client. She has changed her name, moved to Portland, and essentially is living a completely different life outside that of her teenage child. So that's kind of where we're at today. But I think getting an order in place on an ex parte basis, allowing the child to enroll in the Longview School District is appropriate in at least some form of progress.
Ms. Turnbull, anything you wanted to add?
I have not been in contact with either party since I filed my report, but I did review the pleadings in advance of this hearing, and I am definitely in support of the child being enrolled in the Longview School District. I know that when I did my initial investigation a couple of years ago, that the child and the father had a close relationship, and they were spending, part of the week, every week together when the father had days off from school. So that is a safe environment for the child to be in.
Do you have an order for me, or do
I do not. I was hoping you could just, I know pre-COVID days, and then we're trying to get back into what it looks like moving forward. There used to be just a bench order in your stack of forms that the court could sign. I think that would suffice for Longview. I just said something that has your signature on it, ordering the child to be enrolled in Longview, I think is probably as basic and generic as we need at this point. And if there's problems with that, which I don't anticipate, then we can address it on the 14th. But my understanding is that's the only thing the administration needs. I'm happy to go back to the office and prepare an order as well.
I'm writing it. Okay, so first off, in regard to that request, the court is ordering that the minor child be enrolled in the Longview School District immediately by the father, Larry K. Simmons. So that's done there. In regard to the restraining order based on the files and record, the court grants the restraining order as requested on April 2nd, 24. In particular, the mother is not to disturb the father's peace or the peace of the child. Further, the child is to remain with the father subject to the parenting plan I believe you had proposed. And then the child support will be set in accordance with Washington State child support and the figures that you have for that. And then in regard to attorney's fees based on the failure of the mother to respond, do anything, and the necessity for this hearing, the court does order $750 will be paid by the mother to Mr. Zanni's office within 90 days of today's date.
Very well. Just pending the review on May 14th, I'm assuming.
Correct.
Okay, very well.
Leave Miss and then I close May 14. Okay.
I am present, Your Honor, but there's no child support issues today.
Okay. All right. So with that, I received a motion, but I'm not aware of any responsive pleadings.
Yes, Your Honor, I have something to say about that. This time it's appropriate.
Okay, go ahead.
Yes, so I would be asking for a continuance. The reason is that it appears the party sent an email to us. It was quarantined by our system, and so therefore it was not actually received. It's a defense mechanism that the system has in place, and so I didn't receive it. I didn't receive it until my paralegal downloaded that information from the court system yesterday. I did communicate to Mr. Anderson several days ago that I had not received the pleadings. And then his office responded late yesterday with who the information was sent from. And therefore I was able to backtrack it and find out that it was captured by our quarantine mechanism. So I haven't had a chance to respond. There are some factual issues at dispute here that are in dispute. And so I'd ask for a continuance for those reasons.
Mr. Anderson?
Thank you very much, Your Honor. Ken Anderson here for Mr. Day. Your Honor, anticipating that the court would continue, we are asking for some immediate relief here. And typically I would be in agreement that the matter be set over, but there appears to be some just problems with communication with Ms. Turner's lawyers. And we are asking for a ledger for the trust account be provided by the end of the day. We've been asking for it since January. I believe that the rules of professional conduct require that it be kept up to date, and I really don't understand why it can't be provided. 1 year ago, this court, or in May, so 11 months ago, this court ordered that the house would be sold and the proceeds be used in part to pay certain debts. The court did not rule then where the additional proceeds would go, and it was done by agreement that it would go into the IOLTA of Pacific Cascade. However, there's no longer an agreement to that effect, Your Honor. We are asking that the funds be transferred to the IOLTA of the Cowlitz Law Group. We would hold it until further order of the court. We are asking, besides the release of the ledger, that that be done by the end of day. I'm baffled and very concerned. Mr. Trotter is not the original attorney. I'm not the original attorney. This case has been around quite a while. I have spoken to Mr. Trotter, but we are asking that the ledger be turned over by the end of day and that there be a per diem penalty if it is not. And again, we would ask that the whatever funds are in the trust account of Pacific Cascade, that those be transferred to the Cowlitz Law Group, and restraints remain in effect. I don't know the court's calendar for going forward. Did the court, I got a hint that the calendar is full for May 14th. I don't know, but
I'd be fine to add this.
okay. If not, we would actually prefer that this be done on a pretty short basis with a pretty quick return date. That if possible, that we have it heard on April 30th. Counsel has had notice of this for a few days, and they could have I didn't realize they didn't download the documents last Thursday when I think they became aware of it. But if we could have their response by Thursday, we could do a quick turnaround. I'm begging the court's indulgence that we have our reply to the court next Monday and that this could be heard on April 30th.
Unfortunately, I can't do that because it's spring conference, so we are not holding any dockets.
I understand. Thank you for listening.
So unfortunately, that's why we're getting into May already. So I'll address that further here in a minute. Anything further, Mr. Anderson?
No, thank you very much. Thanks, counsel.
Mr. Trotter, anything further?
Yes, I'm just asking for an opportunity to respond to the question of whether the funds be transferred. Again, there's some factual, some issues in dispute there that I'd like to address at a later time. I'm happy to get the accounting department to provide the release of the ledger. And so, yes.
So here's what I'm going to do. I am going to go ahead and add this to May 14th. That docket is closed now. I will not be adding anything else. And I know that's longer than what Mr. Anderson would like. At the same time, it's going to be subject to some conditions. The court has significant concerns as to why a ledger has not been turned over. So with that, what the court wants is the Pacific Cascade Legal shall make a full and complete accounting of the proceeds received from the sale of the property of the parties no later than April 30th, 24, and provide that accounting to the respondent's attorney, as well as file a copy under seal with the court no later than April 30, 24 at 3 p.m. Secondly, the court does want a ledger of the IOLTA account provided to Mr. Anderson by 4 p.m. today. So I want both an accounting as well as that ledger.
Yes, Your Honor.
And if that is not followed through on, then the court will be looking at sanctioning at $100 per day for any late delay of failing to provide that IOLTA account information. I will go ahead and set this matter over, as I said. Well, I'll go ahead and set it to May 7th. That it's full, but I'll go ahead and do it there. I'm very concerned of what's going on here. Okay.
I thank you, Your Honor.
Thank you.
Thanks,
Thank you, Your
counsel.
Thank you.
And I know I've misstated this before. It's Racket.
Racket.
Okay. She's here in the courtroom, Ms. Bliss, just so you know.
Thank you.
All right. So I know this matter was set over. We were waiting for documents from Guatemala. I don't know if those arrived.
No, Judge, I did receive an update late last week. I believe it was Thursday. I've been sent screenshots of the documents that are being sent via mail, but I've not received those yet. I did see, it was Thursday of last week is when I received those. They indicated that they would be sent via the Postal Service, but again, I'm at the mercy of the Postal Service, at least at this point. So at this point, I guess it's my request, again, unfortunately, to set this matter over. I do think Your Honor needs that information to make an informed decision as to whether or not this marriage is even valid.
Right. Any response?
I do know that he hired, I don't know if the papers, the letters that they're waiting for is coming from exactly Guatemala. He does have an attorney in California he hired to make sure that there was a signature that was missing from her to make it valid. So he hired an attorney about, I'm going to say about 4 or 5, maybe 6 months ago in California.
Okay. Well, I don't know anything about that. I don't have anything.
I don't know if his
about
attorney, Miss Bliss, knows anything about that, but he did hire an attorney.
Okay. I don't know.
Okay.
At this point, the only request for the court is a continuance to allow them to get the documents that they, Ms. Bliss has indicated coming from Guatemala.
Okay.
Okay. So Ms. Bliss, any suggestions on time? I don't want to get everybody here again just to.
I know the 14th is closed, the 21st, that's putting us 1, 2, 3, 4 weeks out. I think that may be doable. Obviously, we would need to also have them translated because they are in Spanish. So I guess maybe the June 4th would probably give us enough time. I'm going to defer to the court.
June 4th, does that work for you?
I would prefer for it to be out 6 weeks.
Just about 6 weeks.
About 6 to 8 weeks, just to give them a little bit extra time. I'm very lenient on this stuff because I know how long it takes to get stuff from Guatemala and stuff, so that way they have a little bit extra time and stuff. Is 8 weeks would be it by then?
8 weeks would put us at June 18th. I'm comfortable with that if she is.
Okay.
That is totally fine.
Okay, so let's go ahead with June 18th at 9 a.m.
Okay. Thank you.
Thank you, Judge.
Matter comes on for a few different matters. We have Mr. Zandy here in the courtroom. We have Savannah Williams that is present, and Ms. Williams is only on the contempt matter. Let's see.
Should just be number 4, Judge.
4. Okay, that's what I was looking for, was the language on number 4. I wrote it on the wrong place. That's what I've done. And then we have Jennifer Schaefer that is present. I see Jamie Boaglio, and do we have Mickey Boaglio, Mr. Boaglio?
I'm here, Your Honor.
Okay. All right, so with that, Mr. Zandy, I will turn this over to you.
In which order do you want to go in first, Judge? You want to start with the presentation of the adequate cause and GAO order from
I
last month?
would.
I guess it's just the adequate cause order. I did receive a couple of objections to that proposed order from Mr. Boaglio a couple of weeks ago. It looks like there's about 3. He goes into detail expressing his objection over those 3 provisions. I'll let him address those and respond accordingly.
All right, Mr. Boaglio, on the proposed order on adequate cause,
Yes, Your Honor.
you had some objections to it.
I did. My main concerns were just sticking to what it seemed like you had communicated via the court minutes and our time together. So they had just deviated from that and included some opinion or allegations. And if some of those allegations were included, it just didn't seem like it put the best foot forward for allowing the court investigator to exhaust all her options in finding the truth of what was going on. So I didn't want to see her limited at all, and just for the best interest of the child, that anything extra or any other allegations be either eliminated or that I would be allowed to include my own allegations and concerns, just so that her investigation would be able to be exhaustive and for the best benefit of the child. Anything else I think was just seemed to deviate from what was expressly communicated by you.
Mr.
I
Zandy?
don't know what specific provision he's referencing. I think that's part of the GAL order, in which we did discuss at length, and the court did express significant exhaustive concern about some of the past behaviors and actions of Mr. Buaglio, saying this is one that you specifically remember from years ago, and the types of conduct that is reflected in the GAL order. There's also the catch-all provision, which says any other issues that may affect the health and safety of the children. So I think it's all in there. I certainly trust Ms. Schaefer, whoever's gets this case next, if that happens, to be able to go through that and look. But again, the adequate cause determination was based on a lot of the conduct of dad and the negative impact on this now teenage child. So we do believe that accurately reflects the order. Same for the order on adequate cause. Again, I think that does contain specific findings that you made directly. I don't think there's anything that is certainly nefarious involved in that. That was just directly from the bench that day. So everything in there, I believe, does subscribe with what the court ruled and ordered at that hearing a month ago. We're asking you to enter the order as such.
So in regard to the only order in front of me today is the order on adequate cause. Based on that, it's based on my rulings and my findings, not your allegations. These are the matters that I addressed, and there's really very little in here. So with that, I will be signing off on the order. All right, with that, let's go ahead and go to the contempt.
And again, Your Honor, this matter comes before you on my client's motion from last month. It's again, I feel somewhat like a broken record as it pertains to the allegations and the behaviors of Mr. Buaglio. It's an individual who has been found in contempt by this court in the past. This is an individual who's been told countless times by different judges and triers, in fact, that the conduct needs to stop. And unfortunately, that only prompts him to try harder. And again, the effect of this was blatantly evident on McKenna, the older child. Now we're starting to see with the younger child, Adiel, who is much more sensitive than her older sister. Again, a direct effect on this. This child is struggling. This child is being grossly manipulated by her father. I think if you look at the forms of alienation, this seems to me to certainly be paramount and equate to that. And dad just continues to put it on harder and harder and harder. Specifically, concerns from my client raised in our contempt motion are pertaining to paragraph 14. A lot of this language in paragraph 14, again, that's under the other provision, the other section of the parenting plan, which we largely take for granted. The court did not do that in this case. It was a case where Judge Bassett heard the trial, heard the remaining issues a couple of years ago, entered the order, and made it very clear, specifically to Mr. Buaglio, as did the GAL in this case, that this needs to stop. This type of pattern of behavior needs to cease immediately. And the court put very specific terms in that parenting plan, again, related to the ongoing pattern of conduct of the father. If you look specifically at paragraph 14K, and again, this is one of the big ones, it reads specifically, the children shall remain in counseling as necessary. Both parents shall remain involved in the counseling process as recommended by the counselor. Neither parent shall take unreasonable measures to exclude the other from participation. Everyone has tried, my client has tried to get Mr. Buaglio on board with this. And again, this is kind of a resounding theme. This is kind of the game he plays. Back a couple of years ago, again, this is contained throughout the pleadings and was part of the court order prior to the time of trial. He would unilaterally sign the child up with counselors, one being Alice Potter. Wouldn't inform my client, wouldn't include her in those. Now we have the other side of this. In this case, the child is seeing a counselor at Northwest Psychological Resources. She's been seeing that counselor for a period of time. Mr. Buaglio has not initiated by him and has taken active steps to try to circumvent that and to try to essentially brainwash the child into thinking, well, you're 12 years old now. It's your decision to go to counseling if you want to. You don't have to tell the counselor. So again, he doesn't really dispute that. In fact, he doubles down on that. If you look at his objections to the proposed order, he states, I just want to make it clear that once Adielle is 13, she can essentially do what she wants to with the counsel. Again, that's contrary to the order. I think if we look at this from a global perspective and outside the bubble, it's clear to see what's going on right now. He basically wants to dictate to this 13-year-old child, dictate to my client, and basically dictate to the process while thumbing his nose at the court during that investigation, that essentially he's going to do whatever it is he wants to do, and the counseling he sees as a threat. We're asking for a contempt on that. It's largely undisputed in his responsive pleadings. He kind of offers some justification. Well, I kind of tried, but here's a text message that I sent. Again, we got to get to that here momentarily, from a phone number that may or may not belong to him, to the counselor. But very specific language, unreasonable measures, neither takes unreasonable measures to exclude the other from the participation, and the child remain in counseling as necessary. My client has done all of that, again, over largely the very passive aggressive acts of dad to my client and the counseling agency, and very direct communications to the child saying essentially, it's your decision what you want to do, contrary to the court order. Asking for a contempt finding on that. Secondary to that, again, paragraph 14K, neither party shall involve the children in any aspect of the litigation. This matter may be brought back for review if either parent believes this provision to be violated. The trial in this case was on, I believe, May 5th. By May 8th, this provision was being violated. My client details for you, and again, the response from Mr. Buaglio is somewhat convoluted. My client goes to pick up the child for the visit. Mr. Buaglio and his wife, who is very, very highly involved in this case, decide to walk the child out and engage the child in front of my client. Are you going to tell Adielle essentially what the parenting plan is? This is what you wanted. This isn't what I wanted. Are you happy? What does that do to then, I believe, an 11 or 12-year-old child? Puts them directly in the middle of the conflict and does exactly what this provision is trying to avoid. And again, that's including the child in all of this. Dad goes further than that. We provided you, and this was at the basis of our argument a couple of weeks ago for adequate cause. Sits there and again tells the child, engages the child in these activities of, well, when you're at your mom's house, basically isolate yourself in your room, draft your journal, and here's the 31 things that you can do outside of talking to your mom, outside of talking to my client's new boyfriend who's been around for a long time. He's not new in the traditional sense. Outside of communicating with your older sister, who again, dad has taken intentional steps to isolate and villainize throughout this process. So he's basically taking this child and saying, you know what, we're going to remove you from all of the people in your mom's family because they essentially don't think like us. That's directly in contrast to what this order certainly and specifically states. And again, this is, Your Honor said this at the contempt years ago. Mallory Smith, who was the then GAL, includes this in her report. Judge Bassett made it very clear. These are the ones off the top of my head. He's heard it time and time again, but he still continues to go back to that well of dysfunction for these children. He basically villainizes the older child, McKenna. Basically tells Adielle, informs Adielle, and gets her information about my client being crazy and having mental health issues. And this is how this matter started years ago, putting the child in a position basically to choose between mom and dad. He phrases it in terms of basically right and wrong, based on how you believe and what you think, and that's where you're at. And you're clearly on line with us, Adielle. What your mom is doing is wrong. You get to make essentially a decision to that. Tells my client again in the text messages, regardless of what the court just ordered, everybody should have a joint 50-50 parenting plan. That's what's best for Adielle. That's what she wants. Child comes back and parrots what dad says. Says to my client, this is what you want, mom. You can change it if you want to. These are all on return visits from dad's house. And again, he doesn't do a lot to directly dispute this. He just kind of makes excuses for the action. And instead of taking accountability for this, he points the finger at my client constantly. He points the finger at anybody who doesn't subscribe to what his theory and what his desire of this is. And again, that is a detriment and that is toxic to these kids, especially the one in question now, Adielle. That is certainly a form of alienation. As a form of abuse, it shouldn't happen. He then solicits his now wife to come into that. And again, pour more fuel to the fire. Again, encouraging her to do these things. This is the case we explored last month, where they have this basically timeout time where she goes to dad's house and they start every visit with an hour of basically going over her journal and talking about the things that happened at mom's house. Not only with Mr. Guaglio and his wife, but the extended family as well. The same grandpa who sent the message to my client about her now boyfriend not going to church and being atheist. Again, these are the messages that are being relayed to this 13-year-old child, which does what? Puts her in a position of having to choose between mom and dad. This is not the circumstance where we're teaching, okay, mom and dad are different, their marriage didn't work, but we love you equally. You have two good parents who care about you. That's not dad's tactic. Dad's tactic is, I'm right, I want to win. Now here's how I'm going to influence and manipulate my child to get what I want. And that's the tragedy in this. And now we're seeing the effects of that with a 13-year-old child who's going to counseling, who goes to my client's house and is extremely withdrawn, angry, and confused. And that's all caused by a lot of this stuff that dad, unfortunately, is doing. Look at my client's perspective to that. What's her approach? She does what's been advised, not only from me, but this court and the GALs in the past life. Don't worry, this will all work out. You don't need to concern yourself with any of this. And what's the child say? Again, this is what you wanted. You can change it if you want. Again, parroting what dad has routinely told her since this matter began years ago and continues to amp up to where it's at today at, again, a toxic level. We're asking for the second contempt finding related to communications with the child. Thirdly, paragraph 14B. This provision requires the parties to communicate, quote, via text messaging any non-emergency issues related to the children. What does dad do? Dad, after trial, knowing that this order is in place, insists on all the communication going through stepmom. So stepmom has her phone, my client's instructed by them to essentially use that. My client has no idea who she's talking to when she's texting Mr. Guaglio about issues involving the children. In response to that, we get moving targets. Ms. Guaglio, the current wife, responds along the lines of, well, Mickey's not going to be using a phone and isn't going to have a phone for any time in the near future. We're not big on screen time around here, so there's no plan to replace it anytime soon. Information provided again contradicts that. In his own declaration, we get multiple phone numbers. We get numbers to the counselor that don't subscribe to the numbers that my client's been using. The child provides information that, well, dad's constantly on his phone, text messaging, Facebooking, social media, music downloads, all that different stuff. Dad has his own phone, but dad chooses how he wants to communicate. Again, that's a violation of the order. It's another prime example. I'll be interested to hear the GAL's take on this because this has been an issue and prominent throughout. This is an ongoing problem. And instead of getting his phone, and it doesn't have to be anything expensive, dad would rather play games and say, well, you know what, you're going to go through my current wife. And if I respond, then I'll respond. But 90% of the time, it's probably the wife. And we don't know. This is an issue. We're talking about two kids. Both kids have been in significant peril for the past 5 years. He's completely excluded himself from the relationship with his older child. And again, we're starting to see similar lines of being crossed by him that he just doesn't appreciate. This is another prime example. So my client reaches out about these issues. What's going on in her? We provided you a sampling of those. And we're told basically, well, that doesn't happen in my house, figure it out. We're essentially told, well, Mickey doesn't have his own phone, so you're going to have to go through mine. And you're constantly playing games with a very simple, basic, clear provision of the parenting. Again, that's in violation. Again, the timing of this is beyond coincidental. This is done again for him to snub his nose at the court and as a game to my client, knowing that this is going to impact her relationship, not only with the father, but the children as well. Those are the three we came. We think clearly the evidence is overwhelming. We think the presentation throughout this matter has again been not one of accountability and taking responsibility as a parent saying, I can do better. This has now turned into a game. This has turned into, well, McKenna is clearly sided with mom, not recognizing it's largely due to his own actions. But therefore, I'm going to try to manipulate the younger child. I'm going to try to alienate the younger child from mom because I want to be able to have the satisfaction of knowing, okay, great, I got the last laugh. That's clearly what we're doing. There's information, and again, I'm going to dovetail a little bit with what's happened since the hearing. And I think this will probably be part of Ms. Schaefer's response. During the course of the hearing, we've had issues with social media in the past. Ms. Guaglio, the current wife, is doing a play-by-play on Facebook about your ruling, about my argument, about what's happening in court, asking for prayers and thoughts of everybody who's on essentially their side. What does that do? That goes directly to the children, which goes again directly to Adiel. We have further information where Deegan, the stepbrother of Adio is at school telling her about what's happening in court, which makes her panic. When we have a counselor from school sit there and say, well, boy, maybe this Alicia person, well, boy, maybe we need to figure this out and resolve it quickly. And we need to tell somebody. And again, this blows up. It's just more gas on the fire that's completely unnecessary. They don't get it. And that's concerning. I'm not sure what the end game is. If the end game is to destroy both of your kids and your relationships they're with, he's succeeding. He's already done it with McKenna. If this is to put them in a healthy position, especially Abiel, who was on the verge of crisis, put her in a healthy position to have a good relationship with mom and dad, and worry about typical 13-year-old stuff as opposed to what she's going to be saying to grandpa and grandma and stepmom at the next family prayer meeting at the dinner table. He's doing a great job of that. She is confused, she is scared, and she has no idea right now how to self-regulate. She's seeing Charlotte Rose in family counseling with my client so that my client can piece that relationship and try to patch it back together based on the infliction of the damage that dad has intentionally done. Child has been seeing Janice Schmutz. Mr. Boyago gives you a list of counselors in the past, and of course he wants to handpick those. And now is taking a directly opposite approach to that, saying, you're 13 now, you get to decide if you want to talk to Ms. Schmutz. Regardless of the court order, regardless of what's best for you, you get to decide. What does that do for the child? Again, puts her in a position of being 13 years old, and 33-year-old adults can't figure this stuff out, let alone a 13-year-old who's now put in the position of, boy, it's either dad or mom, and dad is really telling me more than mom is in violation of the order. And I feel sorry for dad, and dad is intentionally alienating me and trying to negatively impact that relationship I have with my mom and my sister and my potential stepdad in time. He's trying to impact all of that negatively and influence her again to essentially side with him because they're playing tug of war over a child unnecessarily, and that is shameful. That's what dad's doing. I think it's evidently clear from the pleadings. I think it's evidently clear from his response. I think it's evidently clear from the messages we've given you. And I fear, I don't want to speak out of turn, through the investigation, I'm clear that a lot of this is probably going to come out as well. It needs to stop. We did ask for jail time. Again, how many times does he need to be told before he actually gets it and it actually sinks in? I'm not sure what the remedy is. Frankly, I don't care. I just want it to stop. My client doesn't care what the remedy is. She just wants this to stop. She wants to be in a healthy position with this child. We'll defer to the court's discretion. We'll comply with whatever you do, and we'll reduce that to order. We just want him to understand the gravity of the situation. And this is not okay. This is putting his 13-year-old child in significant emotional harm's way. And that needs to be avoided.
Ms. Williams?
Yes, Your Honor. My client provided a response. I believe I can keep it fairly brief in just to elaborate on what he's filed as well as what counsel has said today. Walking through it, the allegation in regards to counseling, it's highly unsupported. There's no documentation attached indicating what the counselor has said he is required to do, nor what's required of either parent. It indicates that the children shall remain in counseling as necessary and that the parents shall remain involved in the process as recommended. My client brings her to counseling. He has no intention to pull her out of counseling. I believe that some of his words are being misconstrued. The child, Adiel, has turned 13, meaning that he cannot participate in counseling with Adiel. Absent Adiel's permission, he cannot get any information from the counselor, etc. So it limits his ability to be able to participate in the counseling, but he's in full support. After discussing with him at length, he believes that counseling is most appropriate for Adiel given all that she has gone through. There's no indication that he's stopping that in any way. In fact, it really only is shown in support of the counseling, given that he supports Adiel journaling, which is something that is going through counseling to circumvent or stop the child from venting to either parent. Counseling is in support of journaling. They're recommending it, and my client is in support of that as well, and he's showing that through allowing her to journal. He plans to continue to support her in counseling. Adiel has continued to go to the counselor. There's no evidence or support that he is not doing so. Absent that or a clear indication of what is required for him in counseling, we'd ask that the court not find him in contempt in regards to that. Moving forward to the conversations regarding court, it appears that a lot of it is back and forth. While the child is 13 years old, she is aware that things are changing and she's very naturally curious. My client has not disobeyed a court order in that regard. The written motion from the other party has only said things that they're claiming that she can only learn from her father when discussing court proceedings. But the only kind of allegation that was written in there is that she comes back to the mother and says that she knows the mother can change that if that's what the mother wanted. It's unclear that that would come from my client, and she has an older sister that she has seen that happen with. It's not a direct indication that that's coming from the father, as well as Mr. Zandy pointed out that potentially the stepbrother is coming to go and talk to Adiel about court. That's a clear indication that there's conversations being had outside of my client. There's nothing that directly correlates to my client having those conversations. It's not an argument meant to turn and point fingers towards the mother or anything of that nature. It's rather just to shed light that some of this is falsely being brought forward, or that there are other alternatives. Adiel is intelligent. She's 13 years old. She is aware of this court proceedings have been going for quite some time. So we would ask the court not find contempt in that nature either. And then lastly, for the communication through texting, my client has no objection to that. In fact, he has done so for quite some time. There is some concern in regards to the photos provided by the other party in the motion, as they are misleading to the court. The screenshots are saved under the name Nikki, which is my client's current wife. However, my client took over that phone back in December of 2022. He provided that phone number to the mother, as that is his working phone number. Nikki, his wife, has a brand new phone number as of December 2022. They have texted about the child through that phone. In regards to the phone list, it was more so that he was not going to be getting a new phone, but rather they would share one. That immediately changed within about a month or two, given that was not working out for them. They needed separate phones. So he took over that phone number that's saved under Nikki, and his wife received a new phone number. This was all provided to the mother, indicating that that phone number is fully his. That's what the child refers to when she refers to her dad having a phone. The allegations of that are back from 2022. They've been texting the past year over about the child. So it's quite old and has since resolved very quickly, given that he provided notice that that is his phone full time, that is him on the phone. So we'd ask the court to not find in contempt on that allegation either. Overall, Your Honor, the standard is bad faith. It's not clear that he has done these things in bad faith. The ask for jail time is quite large, and it's asking for the court to find that my client is unwilling to comply, where there is just no evidence as such. He takes the child to counseling. He does not talk about the court proceedings with the child, and he has successfully communicated through text message with the other party. So at this point, we just ask the court to not find him in contempt in all three of the allegations.
Thank you. Mr. Zandy?
If you look at the information that was provided, I'll work backwards on this as it relates to the text messaging of the phone. Again, you gotta go no farther than to look at the wife's message to my client. He's going phone free for a better quality of life. We're not big on screen time around here, so there's no plan to replace it anytime soon. Look at the email. Again, this is attached as part of my client's declaration as exhibit, which I sent directly to Mr. Guiaglio. I spent ample time talking about this broken phone, because that was another issue with them, and suggest that if there's an issue with the phones, then my client would be open to a parenting app such as Our Family Wizard or something accordingly. We don't get a direct response to him. Again, this is in the email I sent him directly. This is in the same email I sent him talking about negatively referring to my client as some kind of a crazy person or having mental health issues to the 13-year-old. Again, he's been put on notice. We didn't have to do this. We could have ran in court pursuant to the order on contempt. We didn't, because again, we're hoping and praying to foster some kind of a working relationship between these two. He just refuses to do it. So I think that argument from counsel fails to hold any water, given the very information that's presented to the court and messages directly from the wife, messages alleged potentially from Mr. Guaglio directly. The email that I sent him, again, it just doesn't hold any muster for that. So I think that's the big one. The communication with the child, that's my primary concern. And again, if you look at that, and we go from having court, and the court specifically look these parties in the eyes over Zoom, at trial and say, this is not going to be permitted. We're not going to allow this. If it happens again, bring it back. Took him 3 days to violate. And if you look at the communication with that, again, I think that's extremely damaging for this child. And what does it put the child in? And here's the discussion. It's directly from the records, directly from my client's declaration. Walks out, has the child with him. She's getting ready to transition. She said, are you going to tell her what happened in court? She deserves to know, or something along those lines. It's not what I wanted. It's what you want. So what's that going to put? What posture is that going to put this preteen child in, listening to that? My client said, well, again, tries to just kind of pawn that off. And you've got two guaglios sitting there with the child looking directly at her, but basically telling her, well, let's engage the child in this nonsense. And let's make sure Adiel knows it's not dad's fault. You go ahead and tell her what happened. So of course, this child's going to sit there and automatically, when the hair on the back of the neck is going to go up, and she's going to sense the tension, and she's going to feel somehow responsible for that because she knows that mom and dad are having a disagreement over her. She's not satisfied with mom's response of, don't worry about it. Everybody loves you. We'll work it out. The court has decided. She's not satisfied with that because that sounds to, again, the 13-year-old, the same one who's hearing the messages very directly from dad that the court is wrong, that your mom is wrong, that everybody's terrible except for people who think like I do. Putting her in a position to go to mom and asking questions. Questions my client can't ask. Number one, because it's morally incorrect. And number two, because the court has told everybody this is not the stuff you're going to do. So she's put in that position again, going back and forth and not satisfied with what mom tells her because she's getting so much information from dad. It astounds me that we could be in court and people could be sitting at home listening to the message, going through years of litigation like we have, listening to the arguments where we're complaining about the actions of them involving this child, and then take their fight to Facebook or Instagram or whatever it is, asking for prayers and going play-by-play of what the court ordered. And not think that people, again, are going to sit there and talk about that or be engaged in that. And people who on a Tuesday morning who have time to sit there and actually listen to that should probably be evaluated for mental health issues too. But nonetheless, directly pulling people to bring them in to this matter. If that's not about winning and losing, I'm not sure what is. It's despicable, and of course there's going to be an effect on it. Do we expect those people not to be telling the 13-year-old to manipulate the 13-year-old? I think that's a stretch. So here we are. It's the same issue that we've argued time and again. It's the same matter that I brought to the court's attention that my client has complained about time and again for several years. It hasn't gotten any better. Unfortunately, it's gotten worse. We are asking that Mr. Guaglio pay my client's fees. I will say that. Are asking for the civil penalty of $250 for every finding and contempt. I will say that. As far as jail time versus admonishments versus strong, clear orders, I'm not sure what else we can do with that. But we're here requesting jail because that's kind of the last road. That's the last option we have, hopefully to get his attention and hopefully have him realize, along with his wife, who's part of the problem, along with his extended family, who's part of the problem, that this nonsense needs to stop. There's a 13-year-old who's being emotionally impacted by this, and her mental health is not good because she's forced to choose sides. Implicitly or directly, she's forced to pick sides. And unfortunately, that is toxic for this kid, and it's certainly not in the best interest of her. And I'm hoping it stops.
So based on the files and record, and I have overseen this matter for some time. In looking at the contempt matters, first addressing the issue of counseling. In regard to counseling, the court has no question that dad is not cooperating, being a part of it. At the same time, the question is to the court whether or not, what impact, what effect does that have? Meaning forcing or having somebody involved in counseling when you have a parent that clearly doesn't believe in counseling or doesn't want to participate. It's one of those trying to force counseling when obviously they don't support it for themselves, at least by their failure to be involved. So I'm not going to make that an issue. I'm not going to find contempt on that counseling part of this. Although it's not good, that child needs to be in counseling from the many issues that are going on. And it would certainly be of assistance and best serve that child with the idea of participating and helping her work out the feelings and issues that that child has. That said, there is to be absolutely no comment, no statement to that child about that is in any way a negative inference that somehow she should not go. I don't care what you think in regard to counseling for yourself and involving yourself, but that child is to be left alone and allow them to participate in the counseling free from that negative conversation about whether counseling serves her or doesn't serve her or anything else. So no discussions are to occur of a negative nature regarding counseling. In regard to the communicating via text, the court simply doesn't have enough information at this point to make a finding or ruling on a contempt part of this, of whether it's a stepmom, whether it's a dad. I sincerely question and think it probably is a stepmom, but to rise to the issue of contempt, the court cannot make that finding. And again, it should be the mother and father communicating. I do, however, want to order that our family wizard is the type of communication that is to occur between the mother and father in regard to the children. Getting to the issue of not involving the children in litigation. It is so wrong. There is no question in this court's mind that there has been an intentional, willing and intentional violation of that particular order that the children are not to be involved. You may have your thoughts, you may have your feelings. Let those children be children. Stop telling them that this is what's going on in the adult world and putting that stress on them, putting that emotion on them. They have enough to deal with being a teenager and going to school and the issues that they need to be able to have and experience as a child. Stop involving the children in the litigation, directly or indirectly. The court does find a willful and intentional violation of that order and orders that is to immediately stop. There is to be no posting about the litigation on any platform, Facebook, Instagram, Twitter, whatever. It is not to occur. That just puts it out there for those children to see and know what's going on. As to the contempt, there will be a $250 civil penalty. Mr. Boaglio will pay the attorney's fees of Mr. Zandy. I don't know what those are. You didn't indicate that, Mr. Zandy.
2,500 on paragraph 5, I state, pay my lawyer's fees and costs if any, the amount of 2,500 payable within 60 days of entry of the contempt order.
So the court will order $2,000 in attorney's fees to be paid within 90 days to Mr. Zandy's office. As to jail time, the court is going to order 2 days in jail. I will defer that for a period of 1 month to see whether or not Mr. Boaglio can basically address these issues properly. And if he can't, the court will immediately take him into custody and he will go to jail. This is wrong. You are harming your children. You need to get it figured out. Anything else, Mr. Sandy?
No, it was just the GAL review. I understand that Ms. Schaefer is still working, and understandably so, given the amount of volume of this case. So I don't know if we want to set over the GAL interim review 4 weeks or so, whatever gives her time. I'm neutral to that either way. Pending her input.
Ms. Schaefer, do you think there's anything at this time?
I feel like I could have a full report to both parties in about 2 to 3 weeks. I wouldn't need an interim. I've been able to speak to both parties, the children, both the school counselor, the outside counselor. I do have one other contact that I was trying to get a hold of, and I was trying to speak to the youngest child one more time. However, she was sick, and now I'm kind of concerned if me continuing to talk to her might be what's making her sick. So if I could just have another week to finish my investigation, and then I could have my report to both parties in about 2 weeks, 3 weeks, and then come back for review.
So Mr. Baraglio, just on the review part of this, do you have any objections to setting it over?
No.
All right. Ms. Williams, in regard to setting over the contempt, are you okay with May 21?
Yes, Your Honor, May 21st works.
Okay. All right, so I will go ahead and set both the, I want to know what's going on in regard to my orders today, and do a review of the contempt on May 21, as well as a review of Ms. Schaefer's report also on the 21st.
Thank you, Your Honor.
All right, that concludes this matter.